Hi, everybody, and welcome to the webinar. Sorry for the short delay there. We had some minor technical difficulties, which we were thankfully able to overcome. So let's get into it. Okay, so today's webinar is regarding title and physical defects in real estate transactions. And first, a bit about our law firm. So this webinar is presented by Cowan Litigation. It's brought to you by Cowan Litigation. We are a boutique litigation firm in Toronto. We serve Toronto, the GTA, and the rest of Ontario. We have 2 lawyers and 3 support staff. And our roots go all the way back to 1903. Here's a little letter from back in the day. And we practice in the areas mainly of real estate litigation and commercial litigation. Our cases have been featured in respective publications, such as Thomson Reuters, Toronto Star, and Mondac. Okay, we have somebody raising their hand. Chris, if you can just check on that person. And Chris, by the way, is my Zoom technician, Chris Grant. So if you have any technical issues, if you can't hear me or anything like that, please speak with Chris. Please message him or put your comments in the comments section of the webinar. A bit about me. My name is Nick Tenev. I started my legal career on Bay Street. I have an engineering background. My undergrad is from the University of Toronto, and I went to law school at Western Law. I am a 2016 year of call, and I have been operating Cowan litigation since 2019 with a focus on real estate litigation and commercial litigation. Okay, so the agenda for today is as follows. The introduction, which we just did, and then we'll talk about first title defects for roughly half the webinar, and then physical defects for the other half. And then we'll have some final words, a little outro, and then some Q&A. Okay. So, oh, somebody's saying I'm muted. So, okay, never mind. It was that person's computer. So if any of you have issues at any time, please message us. We're happy to work through them. Okay. And what is the focus of this webinar? Who's it for? So first of all, it's going to focus on Seminal cases, but also recent developments, so you know what's happening in the courts in recent years. We will focus on Ontario cases because this is a webinar for Ontario lawyers. And also, we'll be looking not only at the cases today, but also what lessons or broader principles we can extract to help you in your practice in future transactions. And the webinar is aimed at real estate solicitors. Everybody's welcome to join, but it will have that angle. So the tips and the takeaways will be geared towards real estate solicitors. And the goal is to keep solicitors current in the law and help them handle difficult transactions better and prevent transactions from failing. Also, we have a few non-lawyers attending, which is great, but a little disclaimer for the non-lawyers and also the lawyers. This webinar is not legal advice. It's not to be relied on or acted upon. It does not create a solicitor-client relationship. And Cowan Litigation and myself are not liable for any information in this webinar or how it's used. If you have any legal issues or questions, seek legal advice right away for your legal matters. And also, there'll be a Q&A at the end. So if you have any questions, feel free to type them at any time, but we will save them towards the end to make sure we can get through the presentation. Otherwise, we might get a little behind if there's a lot of questions. And as I mentioned, any kind of technical comments, please put them in the comments box. Okay, so let's jump into it. So the first topic is title defects. So in this portion of the webinar, roughly half the webinar, we'll be examining some key legal concepts such as root of title. Let me just change something here quickly. The concept of root of title, whether the buyer getting substantially what they contracted for forces them to close the transaction, what is meant by good and marketable title, a concept that is commonly mentioned by the courts, and something that the courts lately have been kind of examining, which I'll call insurable title. And essentially what that means is whether title insurance is a valid solution to a title issue and if it requires the buyer to close the transaction. Okay, so let's start off first of all, with whether the seller has any duty to disclose title defects. And the courts have been pretty consistent, actually very consistent, that the seller is under no general duty to disclose defects relating to title of their property. And we have this case from 2013, which says the vendor is under no duty to disparage his property and may remain silent. You can read the full quote. It adds some extra additional information there that's useful, some exceptions and things like that, which we will cover later. But in general, the vendor is under no duty to disparage his property and may remain silent, and under no general duty to disclose defects relating to title. So we can see the starting point is there's generally no duty for the seller to disclose title issues. So as the buyer's lawyer, you can make requisitions. And it's important to note the 4 types of title requisitions, because these will come into play when we look at what is meant by root of title and things like that. So there are 4 types of title requisitions. The first one is requisitions going to the root of title. The second one is requisitions that are a matter of conveyance. The third is latent title requisitions. And the last one is a title requisition simpliciter, which is kind of a catch-all. So I'll explain all of them. Don't worry, I'm just introducing them. And here's the case which covers them pretty well, this Chan versus Mangal 2022 case. So root of title we'll examine later. There's a whole section on that in this webinar. Matters of conveyance, these are matters that the seller or their lawyer can do in order to facilitate the transaction. So for example, to undertake to discharge a mortgage. So if you can do it, in general, you essentially have to do it. So latent title requisitions, these are rare. I know I have latent defects here, but I should say latent title requisitions. Oh, actually, regarding latent title defects. So requisitions regarding latent title defects. And so these are requisitions which cannot be made during the requisition period by the requisition deadline. So they pop up later. And you might ask, well, how can they pop up later? A lawyer can search title. Well, for example, you can do building and zoning inquiry, and you might get some information that is not totally clear, and then you get more information later which clarifies there is an issue. Or also maybe something gets registered on title after the requisition date, so last minute registration. So obviously those are latent. You could not catch them prior to the requisition date. And requisitions simpliciter, as mentioned, is kind of a catch-all. It's all other requisitions that don't fall under the first 3 categories. So the takeaway here is that the first 3 requisitions, so root of title, matters of conveyance, and latent title defects, requisitions regarding those can be made until the closing date. However, the last kind of requisition, the requisition simpliciter, essentially all other requisitions have to be made by the requisition date. So that's why it's important to know those 4 types of requisitions. So of course, the takeaway here is make sure you deliver your requisitions by the requisition date. However, requisitions that go to root of title can be made until the closing date. And that's why the concept of root of title is important in real estate transactions. Because even if you miss your requisition date, you can say, aha, this goes to root of title, and therefore I am requisitioning it, and you have to deal with it. But the issue here is what is meant by root of title? It sounds kind of a nebulous concept. So let's seek some clarification here. And if you requisition something going to the root of title and the seller does not properly address it, can the buyer terminate the agreement? We will see. So in this 2019 Ontario case, the judge said as follows, and he actually quoted a Seminal case from a long time ago. And the judge explained that an issue going to the root of title is if there is a total failure of consideration and the purchaser would receive nothing at all, not even possession of the property. An objective title on such grounds would go to the root of title. For example, if the vendors were selling in their capacity as trustees and they had no power to sell, or if part of the land were forfeited and vested in the crown, or if the vendor's title might be set aside on grounds of undue influence. Title is the foundation of the contract. Apart from the situation where the vendor has no power to sell, it is difficult to define accurately what objections go to the root of title. So even in this kind of seminal, famous definition of root of title, we see that we're not getting a ton of help. I mean, we can see it's something very serious where there is a total failure of consideration, but the judge here even says that apart from situations where the vendor has no power to sell, it's hard to define what goes to the root of title. And so a takeaway here is that the concept of root of title or issues that go to the root of title, these seem to be very serious or major title defects, generally related to ownership, issues with the seller's power to sell. But it is kind of a nebulous concept, and we'll take a look at some cases to try to help us further understand what is meant by root of title. So the first case here is Brower versus Smith, a 2014 case. And in this case, the property was used illegally by the vendor, and the buyer did not do their due diligence. So they saw the vendor using the property a certain way, and they just assumed, well, they're using it legally. I will keep using it the same way they're using it. And later on, the buyer discovered that, the seller is actually using the property illegally, and I was going to use it the same way they're using it, and I cannot. And the property was being used for some kind of transportation or storage purposes. Somebody mentioned they cannot see the PowerPoint presentation. Can everybody see the presentation? Can somebody else let me know?
It looks fine to me. I think it's just to that person. I'm working with her.
Okay. Okay. Okay, so back to the case. This property was being used for transportation storage purposes, but it turned out it was a residential property and it cannot be used for those purposes. And the court said that the property being used illegally does not go to the root of title. So you can see the court here in paragraph 53 said, I have concluded that the illegal use of the property by the vendor does not affect the vendor's ability to transfer title to the purchasers. And it goes back to what I said earlier, that root of title goes to the vendor's ability to sell the property, their ability to transfer title. And the court highlights that here. Okay, so let me just adjust something here. Second. Okay.
That's good.
Just adjust a little. Apologize about that. Okay. So the second case is a 2021 Ontario case. And in this case, again, we see a situation of illegal use. So the property was being used as a fourplex, but it was in fact only a legal triplex. And in this case as well, the court said this situation does not go to the root of title. In paragraph 42, the judge said, I do not find that the potential unlawful use of the property as a fourplex or the lack of a record of inspection regarding renovations made 45 years earlier are issues going to the root of title. So we can see again that illegal use does not go to the root of title. The next case is EPRF Holdings Limited versus Fergus Bloor, and it's a 2024 Court of Appeal case. And it involves open work permits. And the court specifically in this case said the permit could expose a property owner to work orders, expensive remedial work, and potential litigation. So in this case, the work order was not kind of this benign work order. The court found that it could result in kind of potential litigation and remedial work. And the court found that it does go to the root of title. And in reaching their decision, the court referenced previous cases and said, courts found that an open permit could expose a property owner to work orders, expensive remedial work, and potential litigation. Where the purchaser's right to enjoyment of the property is by no means certain, the open building permit is not a minor defect, but rather goes to the root of title. So some of you might be confused because we just saw cases where the illegal use could potentially result in litigation as well. And the buyer arguably might not enjoy the property the way they intended. But in this case, the court indicated that work permits do go to the root of title. And these work order decisions have caused some controversy, and some lawyers don't fully agree with them or like them because open permits are not registered on title. So permits are not registered on title. So some lawyers have said, well, why is it a root of title issue if the permit is not even registered on title? So they have caused some controversy, but that's what the courts have decided. And in this case specifically, the court said title insurance was not available to cover this open building permit. And the seller has the obligation to have the work permit removed or cleared. And the buyer is not obligated to accept a statutory declaration and the undertakings offered by the seller. So we also see some insight from the court that a statutory declaration or an undertaking is not sufficient either. But the court does hint that if there was title insurance, that might have been a valid response, and the buyer would have to close. And so the court concluded in this case that the buyer had the right to terminate the agreement. So what is the takeaway here? The takeaway is that it can be hard to predict what the courts consider as a root of title issue or requisition. And the significance of root of title, the concept of root of title, is that the buyer might be forced to close or might not have recourse against the seller if the issue does not go to root of title. So the concept of caveat emptor, being buyer beware, applies. So essentially, it's something the buyer should have discovered earlier, or they just have to take on this issue. So it's important to know what's root of title because it lets the buyers off the hook or to have recourse against the seller. And we can see here the Brar versus Smith case from 2014, where the court emphasizes this, that the illegal use of the property in that case is not a defect going to the root of title, and the principle of caveat emptor applies. Essentially, the buyer is stuck with the issue. They have no recourse. So what if there is a title issue, but it does not go to the root of contract, the root of title, and the buyer still refuse to close? Is there any hope for the buyer? And the answer is that possibly, if the seller cannot convey substantially what the buyer contracted for, then the buyer can potentially get out of the contract. And we see this in the Seminal case from 1990, the Stefanovska case, where the court said, in my respectful opinion, the test to be applied in cases of this nature is whether the vendor can convey substantially what the purchaser contracted to get. In this regard, all of the surrounding circumstances must be considered to determine if the alleged impediment to title would, in any significant way, affect the purchaser's use or enjoyment of the property. So we can see the courts also consider whether the buyer is getting substantially what they contracted for. And so you might ask, well, if the seller is conveying substantially all that the buyer contracted for, is the buyer required to close, or can they still get out of the agreement of purchase and sale? Can the buyer still refuse to close? And the answer is possibly. So there are further tests or legal principles which the courts look at. So the next concept is the concept of good or marketable title. So even if the seller can convey substantially all that the buyer contracted for, the seller still has a duty to convey good or marketable title. Otherwise, the buyer can refuse to close. And you might ask, well, what is good and marketable title? And we see from the recent Court of Appeal case, EPRF Holdings, that the court says, and they cite another case, this Seminal Holmes versus Graham 1979 case, and the Court of Appeal says, a purchaser cannot be compelled to take a title which would expose him to litigation or hazard. A good and marketable title is free from litigation, palpable defects, and grave doubts, and couples a certainty of peaceful possession with a certainty that no flaw will appear to disturb its market value. So we can see that the courts explain good and marketable title essentially as a title that is free from litigation. Essentially, the buyer cannot be forced to take on a lawsuit. And you might ask, well, what is the difference between good versus marketable title? Are they the same thing? And the answer is that essentially they're the same thing, and courts have been treating it synonymously, the two concepts, but technically they are different concepts. Marketable title is not as good as good title. So marketable title might have minor defects. It's not perfect title, but a buyer has to take it on. So it's good enough. It's not great. It's not perfect. There might be some issues, but buyer, you have to take it. And that's why they kind of have been essentially made synonymous, because at the end of the day, the buyer is required to accept a good or marketable title. And so the courts nowadays just say good and marketable title kind of as one concept. So if the seller is conveying good and marketable title, can the buyer still refuse to close? As mentioned, marketable title might still have some defects, and the buyer might not like those defects. Can they still be refused to close if there's some underlying or outstanding issues with the title? And the answer is possibly. So, and I say this because with the advent of title insurance, the courts have generally accepted title insurance as a valid response to a title issue, assuming there's adequate coverage. So even if there is a title issue, if title insurance is available, the buyer likely cannot get out of the deal. They likely will have to close the transaction. And if we look at the standard AREA agreement, which if we look at paragraph 10, which I've pasted here, and I mean, this is generally the agreement that everybody uses, that most lawyers, I would say, use in real estate transactions. And if you use some other agreement, it might have a similar clause in it. But we'll take a look at the AREA clause, the AREA agreement, because a lot of the cases in the courts also deal with this particular agreement. So we're just going to focus on this AREA agreement. We're going to assume the situation we're examining, the hypothetical situations we're examining are pertaining to this AREA agreement. And we can see in paragraph 10, if we read it, I'm not going to read it because it is pretty lengthy. It's just kind of a long sentence, but if you read it, it's kind of a bit of a word salad, in my opinion. But essentially, the gist of it is that if there's any valid objection to title, which I've highlighted here in yellow, it can be satisfied by obtaining insurance, in particular title insurance. So we can see that paragraph 10 of the AREA Agreement of Purchase and Sale has this provision built into it that the buyer has to accept title insurance. The seller can provide title insurance in response to a title issue. And I mention this because you might have clients which see a title issue and then maybe are not happy, but you have to show them this clause. So that brings us to the concept of essentially what I like to call insurable title. I didn't invent the term. I've seen other people use it too. Essentially means title that might have an issue, but title insurance is available to cover that issue. And we see in this very important case from 2006 called White versus Goldenberg that the court stated as follows: title insurance was contemplated as a response to an objection under Section 10 of the purchase agreement. That clause is now in the standard Ontario Real Estate Association form. And according to a number of authorities, the use of title insurance is a creative and acceptable answer to a purchaser's title objection in appropriate circumstances. So you can see the courts have said that title insurance is generally a valid response due to Section 10 of the AREA APS. Okay, so let's take a look at a few cases. We'll look at 3 cases, and the first 2 are from the Court of Appeal, and they all deal with title defects. So the first one is EPRF Holdings Limited versus Fergus Bloor Inc. from 2024. So this was a commercial property transaction. There was a $350,000 deposit and closing date in 2020. The purchaser discovered 2 outstanding building permits registered against the property, and they sent requisitions to the seller to remove them. One was removed, but the second one remained open. It was kind of tricky. I think the seller was trying to get rid of it, but there were some issues, some confusion with the township. I think the case also mentioned that it was maybe registered in error. It was supposed to be on a neighboring property. So it was a tricky building permit. And there's more complications in this case and more issues, but that was essentially the main issue, is this building permit that remained opened. And the buyer did not want to close. They said, I don't want to close with this building permit open. I don't want this issue. I don't want to deal with it. Seller, you've been trying to deal with it and you've had trouble. I don't want to take on that issue. And so the issue is, does an open permit go to the root of title? And can the buyer refuse to close, terminate the APS, and get their deposit back? So the court said as follows. So firstly, the seller could not obtain title insurance. So we can see again, the courts look at whether the seller can obtain title insurance to cover the issue. And it's actually the first thing the court analyzed in this case. Secondly, they looked how the open permit would affect the buyer. So the buyer was intending to sell the property down the line or to lease it, and the permit would impede this. And thirdly, the courts appreciated that this was a tricky work permit and that likely the seller would have to bring a court application to get rid of it. And if they couldn't do this before closing, which obviously they couldn't, then the buyer would have to take on that issue and bring that court application. And the court felt that the seller could not deliver peaceful possession of the property. And therefore, the seller could not deliver good and marketable title, which entitled the buyers to terminate the agreement of purchase and sale. So we see in this situation how even an open work permit or building permit can affect title according to the courts, which when we looked at the definition of root of title earlier, it was something that prevents the seller from having the authority to sell, to transfer title. In this case, it's more of a cloud on the title. But looking at it from the perspective of good and marketable title, from that perspective of that concept, the court felt that in this case, it was not required for the buyer to close, and they may terminate the agreement, and that's what they ruled. And they mentioned that there was a potential risk of litigation in this situation over this open work permit. So it was not kind of a trivial thing or formality, but it could result in litigation. So we see in this case, the court analyzed root of title, good or marketable title, and whether title insurance was available. So those are all important concepts that the courts analyze in these title defect situations. And another takeaway is it's hard to predict what a title, what might be a root of title issue, or what might prevent a buyer from closing. Okay, we're running a little short on time, so I'll go over the next 2 cases a bit faster. So in this case, it was a residential home purchase in 2011, and there was a open building permit, and title insurance coverage was obtained last minute, so on the day of closing in the afternoon. And there were some other issues, of course, as most cases have, but in this situation, we'll just look at the title insurance coverage issue. And so title insurance coverage was obtained on the day of closing. The buyers argued that even if it was obtained, they are not forced to close because this issue goes to the root of title. However, the court said that that is not correct. And we see here the court said the buyers are not entitled to terminate the agreement once the vendors obtained a commitment for title insurance in accordance with paragraph 10 of the agreement. So the takeaway here obviously is that title insurance with proper coverage can be a valid response to title issues. And this is pursuant to paragraph 10 of the standard ORVIA APS. And the court also mentioned whether an open permit can be legally characterized as going to the root of title. Title insurance is still an acceptable solution. So I mention this because some lawyers might argue, hey, something goes to the root of title and my client, the buyer, can get out. It doesn't matter if there's title insurance. It's a root of title issue. My client, the buyer, can get out. It's so big, so major. It's a root of title issue. And we can see that the court indicates that's not the case in this situation. Even if it is a root of title issue, title insurance is an acceptable solution. So the last case is this case titled Real M Inn and Resort. And the full citation was provided earlier in the overview of the three cases we're examining. So in this case, it was a commercial property. It had a general store, fuel tank, and there were some work orders that were outstanding regarding these fuel tanks. And they were unresolved. And the seller did not complete the transaction. The buyer refused to close. And the court in this case examined the situation and said that the plaintiff was entitled to consider this refusal, so the refusal of the defendants to address the work orders, as depriving them, being the plaintiffs or the buyers, of the substantial benefit of the contract because in all of the circumstances, they were not able to assess the possible cost of compliance with the orders and any costs or obligations that may have followed compliance. So in this case, the court examines the concept of whether the buyer is getting substantially the benefit of the contract. So you can see that is also a concept that the courts analyze regarding whether the buyer can back out of a transaction. And in this case, they ruled that yes, the buyer can back out because these orders were particularly problematic and reach that threshold where the buyer is not getting substantially the benefit of the contract, which to me at least is not super clear. I can see others arguing that the buyers were getting the substantial benefit of the contract. And the courts also examined whether title insurance was available. It was not in this case. And the case ultimately was decided on the fact that the sellers repudiated the contract, but the court did analyze these issues, which I just examined. So what are some takeaways? It's safer to close with title insurance because if you do not close, the risk of not closing is litigation, plus possibly losing in court. So if your client's the buyer and says, hey, I'm not closing, the issue is they might be wrong. It's not a straightforward analysis. And what can happen is, like I said, if it goes to court, they might lose. And there's also the cost of litigation. If they do close with title insurance, obviously the issue is that the title issue might arise in the future and title insurance would have to deal with it. And sometimes title insurance does not remedy the issue. It just gets passed on to the buyer. And also, if you're acting for the buyer, make sure the title insurance has enough coverage before you decide to close. There's no limitations that might affect your client. Okay, so we examined, in this case, how the courts look at several concepts in deciding what is a title issue and whether the buyer has to close. So we examined root of title, whether the buyer is substantially getting what they contracted for, whether the buyer is getting good and marketable title, and finally, whether title insurance is available. So you have to examine all of those when advising your clients whether they should close or not. You can't just look at root of title or if they're getting substantially what they contracted for. Okay, so that is the end of the title defect section. So we'll move on to the physical defect section. I realize we're running a little behind schedule due to the technical issue we had at the beginning. Okay, let's look at physical defects. So physical defects can be physical or non-physical. And this webinar will examine just physical defects. And by the way, I'll go until 1 and then I'll do the Q&A. I apologize for those of you that have to run at 1, but we will post this webinar. We will post a link of the recording so you can watch the questions at a later time. You can actually type your question and I'll answer it after 1, even if you have to leave. Okay, so this webinar is only regarding physical defects. We're not going to look at non-physical defects. And defects can be patent or latent. So patent means that essentially they're obvious defects. You can see them by walking around the property. So in this case from 2020, the court explained the concept of patent defects and said that they can be discovered by inspection and ordinary vigilance on part of the purchaser. And latent defects, these are defects that are essentially hidden. You cannot readily see them through walking around the property. So the court in that same case indicated that a latent defect, as it relates to the case at bar, is in effect some fault in the structure that is not readily apparent to an ordinary purchaser during routine inspection. So again, essentially kind of hidden defects, hard to see defects. And in general, the seller has no obligation to disclose defects in the property. So in this 2013 Court of Appeal case, the court said the seller is under no duty to disparage his property and may remain silent. And in general, under no general duty to disclose defects relating to title or to quality. So the concept of caveat emptor applies, which many of you probably know what it means. It means buyer beware. Essentially, the buyer has to inspect the property and satisfy themselves. They cannot be, choose to be blind of issues or assume everything's okay or assume that the seller will tell them if something's wrong. The buyer has to do their own due diligence. But there are some exceptions. So there could be issues that the seller does have to disclose to the buyer. And those relate to latent defects, as we can see in this quote here from a 2024 case. So this is pretty harsh, right? Because first of all, for patent defects, so obvious defects, the seller has no duty to disclose. The buyer has to go and inspect the property and see kind of the obvious defects, the ones that are readily apparent. And then for the latent ones, even for those, there's an exception for the seller to disclose latent defects, but only for some latent defects. So that means there is a subcategory of latent defects that the buyer is just stuck with. The buyer cannot see them through an ordinary inspection. Seller doesn't have to tell them. So the buyer's just stuck with them. It's pretty harsh, at least in my opinion, but that's what the law is. So let's take a look at those latent defects that the seller does have to disclose. And there's a quote here that just explains what I just said, that vendor will not be liable for failing to disclose latent defects he or she knew about or ought to have known. And you can see the court here kind of explains some exceptions, which I'll get to in a minute. So the first test regarding what latent defects the seller has to disclose comes comes out of the seminal 1979 case McGrath versus McLean. And in this case, the court decided that if the property is unfit for habitation or dangerous, then the seller does have a duty to tell the buyer. So this became an exception to the seller having no duty to disclose. So if the latent defect, if the hidden defect makes the property unfit for habitation or dangerous, the seller does have to disclose it. But then we see some further developments. So in 2001, there was another very important case, Swayze versus Robertson, where the court said any loss of use, occupation, and enjoyment of any meaningful or material portion of the premises or residence that results in the loss of enjoyment of the premises or residence as a whole must be disclosed. Any kind of issues that relate to this must be disclosed by the seller to the buyer. So we see another exception here that relates to loss of use or enjoyment, and also clarifies that we don't need to have the entire property to be uninhabitable. Even if a portion of the property is uninhabitable, that might be okay as well. And so it's obviously a more forgiving or softer test than the McGrath test, which essentially says, hey, if unless the property kills you or you can't live in it, you're stuck with these latent defects. So McGrath, carved out a small exception, and Swayze widened that exception. And in my research, I found this very recent case in 2026, where the court said a latent defect is a hidden flaw in a property that is not discoverable by a reasonable inspection that makes it dangerous or unfit for habitation or significantly affects its value. So this might be a new exception if the latent defect significantly affects the value. So I checked the case and I did not see the court citing any cases for this concept of the latent defect significantly affecting the value of property, and that creating an obligation on the seller to disclose that defect. But we can see the courts are kind of evolving this concept of when the seller has a duty to disclose latent defects. Another exception is if the seller is a builder or does construction work. So if they do construction work or are a builder, they do have a special duty of care to the buyer. So we will see there's a case where even though there was nothing dangerous about the construction work that was done by the seller, and it did not make the property unfit for habitation, nonetheless, the court still decided that the seller is liable to the buyer for the shoddy work that the seller undertook. So in this case, it's Olivia versus Dixon 2025 case. And as I mentioned, the sellers were the builders of the house. They did not apply for a certain building permit, and there was an expensive problem with the septic tank as a result. And the courts said that at a minimum, the standard of care of the contractor / seller of the home was the standard set out in the building code. So at least you have to meet the building code. And the court mentioned that they owe a duty of care, the sellers owe a duty of care to plaintiffs. And as I mentioned, the court even mentioned themselves, there was no evidence the home was not habitable or unsafe. So we see that if the seller undertook construction, they might be liable if the construction has problems. And why is that significant? Well, your clients might buy a home. There might be some issue that was not discovered, some latent issue, and there still might be hope for them if the seller performed that work, that problematic construction work. Another exception is concealment. So probably all of you have heard about this. If the seller conceals the defect, then it's no longer a valid latent defect. Concealment is not allowed. You cannot hide defects. And it can result in the buyer rescinding the agreement and seeking compensation for damages. However, it is a pretty tough onus because the buyer has to prove that the defendant knew of the issue and they concealed the latent issue or were reckless regarding the truth. And what is reckless? How can you be reckless regarding the truth of a physical defect? We'll see in some cases what that means, but essentially they have some potential knowledge of it, or there's some suspicion or indication they choose to ignore it. Or when they represent things to the buyer, they're reckless in the representation. They're not clear that there's an issue when they know there's an issue, or mislead the buyer. So we see that in this Cotton versus Monahan case from 2011 from the Court of Appeal that the court said the purchaser must establish the vendor knew of the latent defect, concealed the latent defects, or made representations with reckless regard for the truth. And we'll take a look at 3 cases. So the first one, Bulldog versus Legault. So this is a 2018 purchase of a house in Sudbury. And only a few months after the purchase, there was a water leak. And understandably, the buyers, the plaintiffs, were very upset, and they suspected that it's the seller, that this issue was known to the seller, and that the seller failed to disclose the water infiltration and deterioration of the foundation. So did the vendor know about the foundation problem before selling the property? And so in this case, we can see there's a lot of suspicion because only a few months after the purchase, we see water leaking in. So I think, just like the buyer in this case, a lot of people would think, well, the seller must have known about this. And so what happened? The court analyzed that there were 2 prior water incidents. So remember, the case was from 2018. Sorry, the purchase was in 2018. And the seller had 2 prior water incidents in 2007 and 2010. But these were plumbing leaks, and there was no evidence of an issue with the foundation. And during the repairs of these water issues, or perhaps some other repairs, drywall was removed by the seller, but the seller did not see any moisture behind the drywall. The seller also had tenants living in the basement, and the tenants were witnesses. They testified that there was no dampness, odors, or water problems while they lived there. So I think that was pretty powerful evidence that there were no issues during the seller's ownership. And also during the walkthrough, the buyers did not see any kind of issues with the foundation, any kind of bowing or settling or structural warnings. So the court in this case was not happy with the lack of evidence. So as we can see, there was some suspicion by the buyer, but the court said the evidence was scant. And although they have sympathy for the buyer, unfortunately, the buyers were not able to establish through their evidence that the seller was aware of the issues. So I found this to be an interesting case because the problem started right after purchase, yet the buyer was unsuccessful. And the court said that perhaps there were issues during the seller's ownership, but they were minor, and maybe they developed over time, and perhaps maybe just through coincidence, the issues really came out when the buyer bought the property. It's just coincidence, I guess. But based on the evidence presented, the courts did not find the seller liable. And it was a very expensive issue, around $350,000 to $400,000 to remedy this issue, plus obviously the legal fees of the litigation. So a very expensive issue for the buyers, and they were unsuccessful. So the takeaway is that evidence is very important, and the courts look at the evidence and the balance of probabilities, and there could be obviously huge consequences. In this case, these defects cost around $400,000 for the buyer, and they took it to court and they were unsuccessful. So the next case here is Connelly versus Garito. And this is a 2018 purchase of a residential property in South Porcupine. I had to look that up. That's near Timmins. And so what happened in this case is that the buyer bought the property, and there were issues with water leaking in the basement. And the buyer discovered that there was a secondary concrete wall in the foundation. So in addition to the concrete foundation, there was an additional wall. And the seller, the defendant, argued that he built this additional wall to prevent some cold air and frost buildup. So that was his explanation, that it was built just for the cold air and frost. It was not built for structural reasons to support the foundation or anything like that. And he built this wall, this secondary wall, without a building permit and with no professional oversight. So after the purchase, the buyer, experienced extreme cold, frozen pipes, and the root cause was determined to be a compromised buckle. So it was breaking essentially foundation, and the second wall was shifting. So essentially, the second wall appeared to have been built actually not to prevent frost or cold air, but to reinforce the foundation. And the secondary wall was being compromised as well as shifting. It was not doing its job as intended. And so the court found that just analyzing the situation, that the seller, was likely not being truthful in saying that this secondary massive wall was built essentially for insulation purposes to keep out moisture and cold air. It was built to reinforce the failing foundation. So essentially, he undertook himself, the seller, to fix his foundation, and he was unsuccessful. So the court found the seller liable to the buyer. And the court also mentioned this is a latent defect because the buyer could not have seen this issue when they inspected the property. So the defendant was found liable, the seller, and there was $41,000 in damages. And so in this case, we see the takeaway is that expert witness evidence is very important because the issues can become technical. So in this case, there was a expert witness, as we would expect in technical cases like this, and the expert witness had to explain how the purpose of this wall was likely to reinforce the other wall. It's not for the purpose of keeping out moisture and cold air. So, and I mention this because you might have clients who experience an issue and they call you and they say, hey, this is what happened. Do I have a case? And it's wise to tell them that, just based on a phone call and just based on your opinion as a lawyer and their opinion as a regular homeowner, sometimes you cannot advise much on whether something is an issue. You need an expert. So, your clients should probably call an expert to do an inspection and give their own opinion so you can better understand if this is an issue. And also to ask maybe for a quote so your clients know the extent of the issue. They might think it's a huge issue, but it ends up being a smaller issue. So we saw one case, the issue cost $41,000 to remedy, and the other case, it was more like $400,000. So those, I think, are wise things to advise your clients, to get an expert to take a look and give their opinion to determine the cause. And if the expert witness thinks this is something that likely predated the purchase of the property, if this is something likely that the seller maybe knew about, and also the cost to remedy the issue. Because if it's small, your clients, the buyers, might not even seek to pursue the sellers for damages. Last case here, I know we're running out of time. I'll just cover it quickly. It's a case where there was water issues in the basement and there was concealment, and the seller was saying that, hey, I wasn't aware of this. I didn't see any water issues during my ownership. But the court looked at the evidence and determined that on the balance of probabilities, she was aware or being blind, willfully blind. And the court, for example, looked at the baseboards, which were touched up. The seller said, hey, I touched them up because my dog was chewing them up. And the court found that maybe that was the case, but she would have seen that there was water damage in that area. Essentially, she was probably painting them because they were water damaged. And even if it was because her dog chewed them, she would have seen the water damage. There was also other things the court examined. Again, there was expert witnesses. The expert witness mentioned that a lot of the drywall was removed. There was new drywall. It was more extensive, the basement renovations, than what the seller said. So essentially, it seemed like there was these partial but very extensive renovations, and likely it was due to water damage. So although the seller denied that she knew about it, the court, based on the evidence presented, felt that she was aware of it, or at least willfully blind, due to the extent of the basement renovations done by her and her attempts to conceal, or potentially conceal, I should say. And so the takeaway is that actual knowledge sometimes is not required. The defendant being willfully blind might be enough. Because your clients might ask, hey, how do we establish this? How do we prove that the seller knew about it? And sometimes you don't. You just have to show that they were willfully blind or reckless with respect to the truth. And so that concludes the physical defects portion. So just to recap, the seller has no duty to disclose physical defects, but there are some exceptions, and those are just for latent defects. And those exceptions are concealment. So if the seller conceals the defects, fraudulent misrepresentation. So if they tell the buyer, hey, there's no issue. For example, in the agreement of purchase and sale, if there's a clause saying seller represents there's been no water damage or structural issues in the foundation, and they signed the APS, but then it turns out they knew there was. So of course, that would be a fraudulent misrepresentation. We also saw the McGrath principle, which is that if the property is unfit for habitation or dangerous, then the seller does have a duty to disclose the issue. We saw Swayze widened that principle, and any loss of use or occupation and enjoyment of any meaningful or material portion of the premises or residence that results in the loss of enjoyment of the premises or residence as a whole. So kind of a long explanation, but essentially it's a wider test than McGrath. We also saw the seller as a builder or doing construction work. That's also an exception. They have a duty of care to properly construct things, and if they don't, they have to tell the buyer, like, hey, buyer, I built this secondary wall myself without a permit to hold the broken foundation wall. You should inspect that and satisfy yourself that it's sufficient. I'm letting you know because you won't be able to see it. So there is that exception. And there could be more, but these are just some I've covered, and I think these are the main ones. Okay, so it's 1:03. Thanks for staying until the end of the webinar. I would just mention a few more things. So again, thank you for attending. It was great having everybody here. We'll get to the Q&A in a minute. So think of your questions and please start typing them in the chat, in the Q&A. We'll get to them in a minute. But just to mention a few last things, if you have any questions about anything at all about this webinar, or your clients have litigation issues, feel free to reach out. Our contact information is here on this slide. And we also have a referral program. So if you refer a client to us, we are happy to pay a 15% referral fee according to the Law Society requirements. And we provide practical, efficient, and solutions-oriented advice. We try to resolve issues quickly. And we're very experienced and also very accessible because many times clients are not happy they can't reach a lawyer, but we're accessible and we do a great job, and we have an excellent team here. And so what's next? You can join our newsletter if you haven't joined yet. So you can email us at info@cowanlitigation.com. And also we have a Facebook group that you can join. So we have real estate lawyers there. It's just for real estate lawyers. And you can ask questions. You can ask us. You can ask the group. And it's a private group, like I said, just for real estate lawyers. So I think you'll find it very useful, and we'd be very happy to have you. And also we post a lot of useful content there. So we'll post these slides, and we'll post the recording there as well. Because this one ran late, just email me and I'll send you the recording link as well. You don't have to join the group for this one. And also we'll send you a survey regarding how you like this presentation and suggestions for future topics, things you want to hear about. And we'll send a $20 Starbucks gift card to 2 random people that fill out the survey in the next 24 hours. So please fill out that survey. And the next webinar will be in April. We're doing these webinars on a monthly basis. And the next one will be a deep dive into latent defects. So as I mentioned, not all latent defects are physical. So we will look at non-physical latent defects, and we'll examine various concepts in more detail, such as what level of knowledge is required by the seller. Is a home inspector required by the buyer to detect the defects, or can they just go see the property themselves and still argue that the defect was latent? Do subjective factors matter? So if the buyer had some subjective factors, personal factors that they felt were important. And what if the APS has the as-is clause? What if it says the property is as is? Does the seller still have an obligation to disclose any latent defects? What if the property is unfit for habitation or dangerous? Does the seller have to disclose that if there is the as-is clause? Also, we'll look at cases involving property disclosure forms. So as you know, I don't know if people do them nowadays much, but sometimes there's property disclosure forms which specify the state of the property, and there's cases on whether the seller can be liable for the information in those forms. And also anything else, when you do the survey, you can let us know if there are any other topics you would like to discuss regarding latent defects. And also we'll have a guest speaker, my colleague David Morwitz from Beard Winter. We'll cover also interesting cases involving murder and ghosts. Yes, there is a case involving a ghost in a haunted house. I am not kidding. So we'll have some fun and look at some more kind of interesting cases. And David argued Beatty versus Way. So some of you might know this case. It's a 2018 Court of Appeal case, a pretty famous case, and he was able to overturn the Superior Court decision. So he was successful in the Court of Appeal and overturned the decision. So it's a very interesting case regarding latent defects. The property was used as a grow-op. There's a lot of interesting facts. I think you'll really like it. And you'll get to hear from David. So it won't just be me. It'll be also David talking about his case and some other stuff. So it would be great to have you join us in April as well. Okay, so let's get to the Q&A. I'm just opening the chat here. And sorry, we were late again in the beginning. So somebody asked the likelihood. Chris, are we still recording?
We're continue. I just stopped the share.
Okay. So I'm just taking a look at the Q&A here. So the likelihood tends to be a title insurance coverage may be available to cover the lender. Okay, I did not see any questions. If anybody has questions, please put them in. Or maybe I'm in the wrong box.
In the Q&A, I see a number of them. I could read off the first one.
Okay, I was in the wrong box.
All right.
I'm in the right box now. Okay, yeah.
Okay.
If the buyer asks the seller if the property is good, marketable, is there any recourse if the seller lies? I understand that the seller does not need to disclose defects, but what if they lied about it? So if the seller lied, then that would be misrepresentation. So the buyer should have recourse if the seller said something that was untrue and the buyer relied on it. There's a whole test regarding misrepresentation. So I can't answer this question in the fullest because there's a whole test, but in general, if the seller says something dishonest, if they misrepresent something, then they can be liable. Next question. What if the buyer is forced to close because of title insurance being available, but the buyer's mortgage lender is not agreeable to advance funds? So in that situation, that's an interesting situation. So I don't have a perfect answer, but my guess would be that we would have to look at each party's conduct. So if the lender was not being reasonable, then they might be liable. That's my guess. So if the lender was not being reasonable, they could be liable, just like a buyer refusing to close, a lender refusing to close with title insurance, they might be liable. Now, some people might ask, well, does that make the buyer not liable then to the seller? Can the buyer say, hey, seller, it wasn't my fault, don't sue me, sue my lender? The answer is probably that both the buyer and the lender will get sued, and then the buyer would have to cross-claim against the lender. So that would be my guess of what would happen in that situation. But that's a very interesting question. So essentially, my answer would be the buyer and the lender. The buyer would be liable to the seller because the seller and the buyer contracted, right? The lender has no contractual obligations to the seller. So the buyer would be liable to the seller, but then the lender might be liable to the buyer. Okay, next question. How will the CPD credit be delivered? Okay, I'll get back to you offline on that. With respect to work orders and open permits, at what point in the transaction is the buyer prevented from submitting the requisition? So the question asks, with respect to work orders and open permits, at what point is the buyer prevented from submitting the requisition? So we saw in the cases that the courts indicated that these work orders or open permits go to the root of title in general. So you should be able to requisition that until the date of closing. Has there been a case where defects arose were discovered only later in a transfer from an existing owner to their co-owner? If yes, how would you or the court recommend to protect your buyer or seller in buyout conditions? Well, a purchase between two co-owners, I think would be exactly the same as whether it was not two co-owners. Essentially, you have one person buying from the other person. So you would look at, for example, the defect and only discovered later. So if it was discovered later, now they both own it. I mean, you would, I'm assuming you have an agreement of purchase and sale, the AREA agreement of purchase and sale. So then you would look at clause 10 and also the defect. The question hasn't specified if this is a title defect or a physical defect. I assume it's a title defect. So you would look at section 10 of the AREA form, and you'll see there that if there's title insurance, you probably have to close. So I think it would be essentially the same as if you were buying from a non-co-owner, from a random person on the market. So the fact that it's a co-owner, I'm not sure makes any difference. In all likelihood, title insurance will cover the lender against prospective loss, but not the purchaser, where the title and off-title searches reveal defects. The purchaser solicitor has a duty to reveal the results of the searches, and it is accordingly difficult to insure over a defect made known to the title insurer, which is likely carve out explicit exceptions to general coverage. So I agree with this. Sometimes the title insurance is more generous, provides more generous coverage to the lender, and we have to go back to the core principles. What are the principles from the court? And if the title insurance coverage is not adequate, then we look at those concepts that I covered, right? Root of title. Is the buyer getting substantially what they bargained for, what they contracted for? Are they getting good and marketable title? So you look at those principles, and if you cannot check them off, then the buyer can likely get out of the deal. Just because their lender got full coverage, that's essentially meaningless. because they're not getting full coverage. It's meaningless to them. Like, it doesn't help them that their lender got full coverage. It does help them because they're getting the mortgage, but they themselves will have to possibly take on an issue that can result in litigation, and that might not be good and marketable title, so they might be able to get out of the deal. Does a seller have an obligation to disclose rat infestation? That is a very specific question. So again, going back to the principles, if it is a latent defect and makes the property unfit for habitation or dangerous, potentially, yes. And also we have the other test from Swayze, right? With the loss of enjoyment and use of the property or a meaningful portion of the property. So I'm kind of thinking back to the leaky basement cases, the flooded basement cases. So there's a lot of cases of flooded basements in the courts. And I think that's because it's hard to inspect the foundation, right? It's in the ground, it's covered by drywall. So that's probably kind of a common thing that can result in latent defects. And a rat infestation might be similar if you have to vacate your house, if it makes it uninhabitable or dangerous, that could be a latent defect, and the seller could be liable if they knew about it and did not disclose it. But all these cases we saw are very fact specific. It's hard to say, really, really hard to say, kind of to give a blanket statement of what would be a latent defect that the seller would have to disclose. So with the rats, he would look at what area of the house, how severe is it? Is it like 1 or 2 rats, or is it like 100 rats? So are these rats biting people? I don't know. So, there's a lot of facts to consider. So it's very fact specific. What is the range for legal fees when litigating a failed transaction? So it's really hard to know. And I get this question a lot when clients ask me. And basically, I've had situations where I've had cases where somebody contacts me about something, and we get started, and I send out one letter, and then the client comes back 2 weeks later and says, I don't need you anymore. We resolved it. And then there's other ones that go all the way to trial, so in front of a judge. And you have anywhere in between where things settle. And even if you go in front of a judge, there might be an appeal. So it might go to the Court of Appeal. You never know. It's not common, obviously, but you never know how long it will go, and also how far the case will progress. You also don't know, various other things, the amount of facts to consider, the amount of issues, how aggressive the other side is. So the other side might have a pretty weak case, but they might be super aggressive. So that will prolong the case. So it's hard to know, but usually, it's in the tens of thousands of dollars. So it's very expensive. That's not a quote or an estimate or anything like that, but at least in the tens of thousands. If you're going to go through discoveries, which is the evidence process, and then potentially to trial. So any kind of discoveries, mediation type stuff, going to trial, you're looking at tens of thousands usually, at least. Undue influence is going to the root of title. Any case law you could suggest? Interesting question. So I don't have a case off the top of my head, but you can see there's all these little extra exceptions. I shouldn't say little exceptions, but there's all these extra potential exceptions or matters that go to the root of title. I have to go look at the case again. I can't recall which case that was, and I can't recall any other cases off the top of my head. But if you want, you can email me at info@cowanlitigation.com, and I will try to get back to you if I find a case. Once file is ready for court, generally, how long do the courts take to deal with the matter? Oh, so the courts right now are pretty backlogged. So it takes a long time. It can take years. And right now, even for pretty simple things like case conferences. So case conferences are essentially kind of scheduling meetings to kind of meet with the judge to come up with a schedule for something. If the other side and you cannot agree on a schedule, sometimes those even just take months or 6 months to get a case conference that happened on a recent case. I was really surprised. Usually they would take weeks, and one we required recently took 6 months to get the date. The date is 6 months in the future. And it also depends on which courthouse. Some courthouses are more backlogged than others. But it can take years. And again, it goes back to the other question about cost, where I mentioned a case can progress very far. It can go to discoveries, mediation, it can go to trial. So we don't know where the case, when the case might end. But you did mention how long do the courts take. So assuming it goes to trial, yeah, it can take years. I would say you're looking at least 1 or 2 years, I would say, for a case regarding title or physical defects. Okay, so those were all the questions. Thank you very much for your questions. And again, thank you very much for attending. Just one last final reminder to sign up for the next webinar, or actually just sign up for our newsletter, and the newsletter will inform you of the webinar coming up in April. And I think you guys will really like it. It would be great to have you there. So please join us. And bye for now. I'll see you next time.